Good afternoon. Good afternoon. We have a great news to share, okay? Please go ahead and like, share. Don't forget to subscribe because we are talking about complex immigration law cases. If you're new to my channel, please go ahead and like, share. Don't forget to subscribe, comment below. We're here to help. Um, we're here to help with immigration cases. I want to talk about this case because this is a great case, okay? This person filed for petition in 2022 based on, alien relative I-130 because the person is a lawful permanent resident, okay? It took 3 years, okay? But that's not really the point we want to discuss here. We want to discuss something very difficult we had to overcome, okay? This is a person who was previously denied the application for naturalization. And the reason why the application for naturalization was denied, it's because of failure to disclose, okay? Failure to disclose that he had children. He did not disclose his children when he applied for the DV lottery, and he did not disclose his children on the form D as 260, okay? The form that you apply to get here, the immigrant type of visa petition that you apply to get here, right? He did not disclose, but he had those children before filing for the DV lottery, and while filing for the DS 260, he did not disclose. And when he got here, the 5 years for citizenship was up, and he applied for U.S. citizenship. And he was supposed to disclose his children because now he want to bring them. So when he did that on his naturalization application, the USCIS officer said that, you previously failed to disclose, therefore you lied to the consulate in order to obtain visa, okay? So it got denied. The person filed for the form N336. It still got denied because the explanation that was given, the USCIS officer deemed that explanation not credible, like lacks credibility. But the good news was the case was never referred to court, but he just didn't get his US citizenship. Now the challenge becomes when we apply for the I-130 petitions, actually 5 of them for the children and 1 for the spouse, because he went back and got married later, right? So when we apply for those petitions, we had to come with a solid explanation as to why he failed to disclose. Remember, on his N400 denial letter, they said that because you failed to disclose, lied to the consulate, therefore you were not lawfully admitted. So therefore your green card is not valid because you're not lawfully admitted. But thank God when we did the N336, we had an explanation, even though we did not succeed on that explanation. However, the decision was a little different because the explanation that was given, they said that the only reason they're not going to reverse their decision is because they think that the person lacks credibility, okay? Thank God it wasn't referred to court because at that point the decision has changed. It wasn't not anymore about not lawfully admitted, but it was about credibility issue, okay? So the person kept their green card. So we had to file for the I-130s based on lawful permanent resident and children of lawful permanent resident and spouse of lawful permanent resident. And that's under category F2A, right? Second preference category. And those petitions take forever. 3 years later, it got approved. And the good news is that it got approved just on time, because if you look at the visa bulletin, we are basically on the late date, like final action date. And it shows February 24. So any petition that was that had a priority date before that date that is listed there, it means that they have to file. And those are the like the final action, like you have to file or else it's over, right? Because the visa is has already been available, and those are the final action dates. And thank God it got approved. Even if it didn't get approved at this time, we were supposed to just reach out to USCIS and see what's going on. But thank God they did it before we reach out to them. Well, the reason now I want to go back to why the petition got approved, it's because we were able to bring another argument. Okay, remember we did the argument for the N400. It wasn't successful based on lack of credibility. However, this time around, we had to come with another solid argument so that they can approve those petitions for the children. So, and the solid argument was about the affiliation type of law that they have back there in the Congo, saying that if a man hasn't recognized their children, they cannot claim those children on anywhere. So they have to first recognize the children legally. Otherwise, they're not affiliated to the child in question. This is according to the family code in the DRC. So we're able to argue that, and finally, USCIS agrees with us, and the petition got approved, which what it means later for this petitioner is that next time when he applies for US citizenship, it's going to be actually approved, because now we have a solid argument, and now we have a proof that the children in question was previously not affiliated to him, and after being recognized, now they are affiliated to him based on the Congolese law. So this is a great news. I wanted to share it. Please like, please share, please don't forget to subscribe, and please if you have questions regarding those type of denial, don't hesitate to schedule consultation. Until next time, bye bye.